24 CR 2114 is now called the State of Texas versus Demond Sargent Jr. That is you, present, with your attorney and the state's attorney. Does the defendant waive Mr. Lodge, waive a formal reading of this indictment and arraignment? Can we proceed?
No waived, Your Honor.
In summary, then, this indictment alleges, sir, that on or about September 25th, 2024 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500, and there will be terms and conditions of probation which are normal and customary for this type of offense.
Hopefully this is misunderstanding.
Do you understand this as the agreement?
Sounds quick.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it. Discuss it with your attorney. Are the contents true and correct?
Yes.
Yes, they're correct. Yes, speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
Correct.
It's an objection. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I am going to follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation, which are normal and customary for this. You will be placed on probation for 10 years. That can be shortened to 1/3 for good behavior and following the rules. You will be fined $500. And what is now the relationship? Do you have any relationship with this person?
That's just the mother of my child.
Just the mother of your child.
Yes, sir.
That's no little thing. That's important. So, how are we going to work this out? How do we do this?
There needs to be no contact. And as far as dealing with the child, they'll have to make arrangements through a third party.
That's understandable. What is the name of the victim? Contact, we understand. Will he be released today?
Well, we're going to deal with that just in a moment. There will be conditions of probation. Now, what concerns me, and I'm looking at this probable cause affidavit, is that I don't have a pre-sentence report. I probably ought to order a post-sentence report to look into conditions of probation, which are normal and customary. But the point of the matter is that jumps out is he assaults this lady who is the mother of his child, but she is 5 months pregnant at the time.
That's the child he's referring to.
Okay, Turner was 5 months. But she has been assaulted by her boyfriend.
That child was born after this offense.
Who was 5 months pregnant, advised that the assault started. Say that again, man?
There's no other child. He referenced a child that was born after this event.
Okay, but the victim was 5 months pregnant.
Yes.
Oh, okay, that's the point I'm making.
I'm sorry.
Yeah. First of all, it's inappropriate to assault anybody, much less someone who is 5 months pregnant. I mean, that could, no gentleman, no person should ever do that. That's just off the charts of appropriate behavior. And you knew the lady was pregnant, didn't you?
Yes, sir.
And Your Honor, it has been some time since that offense, and he has not had any behaviors like that since then.
Your Honor certainly can choose to.
What's in the past is never really in the past.
So,
That's a famous saying. And the fact is that what occurred, just like when we have trials here, what we do is we have to relive what happened before and figure it out. I'm going to ask for a post-sentence report. We'll come back. We'll get some more information because it's limited in the information I have, except for this one-page probable cause affidavit.
Do you want to make it a pre-sentence and just withhold?
No, he's going to start on probation. I don't want to, so that there are terms and conditions of probation, which he's going to have to abide by, and he is responsible for it. Again, if you fail, your probation can be revoked. You can be found guilty and sentenced up to 10 years in prison. Do you understand?
Yes, sir.
All right. Please tell the jury we're going to need just a few minutes. Thank them for their patience. Thank you.
Yes.
And you shall also, you will be required to complete this batterer's intervention program, which is normal and customary for this offense.
it's wrong.
No man gets with a lady. That's just off the chart, especially someone who's pregnant. Shame on them. Especially pregnant with your child. Shame. All right, we're going to come back. When can that post-sentence report be done?
Do you want me, we can expedite it if you want us to.
Yes, ma'am.
Okay.
About how long would that take?
We usually take them, it's usually about a month before we do them, but if you want us to do it earlier, we can.
If I reset this for 4 weeks, is that good?
Absolutely.
Thank you.
And he'll be on probation until then.
He begins probation immediately when he signs this document.
Okay.
Yes.
So he'll be released.
We have a verdict.
Thank you, Your Honor.
Thank you. One other case is to be dismissed, correct? All right. We have a verdict in the Horatio Trevino case, please.
You can sit.
We will get ready to receive the verdict.
The courtroom turned tense as Demand Sergeant J.R. pleaded guilty to aggravated assault with a deadly weapon in Jefferson County, Texas. But the hearing took a serious turn when the judge focused on one disturbing fact. The victim was 5 months pregnant during the assault. The judge strongly condemned the violence, calling it completely unacceptable, especially against the mother of the defendant's child. Instead of prison time, the defendant received deferred probation, strict no-contact conditions, and mandatory intervention programs. But the warning from the court was clear: violate probation, and years in prison could follow. As the hearing ended, the judge left the courtroom with a powerful reminder. Actions have lasting consequences, and the past never truly disappears inside a courtroom.
We now call cause number 23-41503, the state of Texas versus Horatio Trevino. The defendant is present with his attorney and the state's attorneys. We've received a message from the jury that the jury has reached a verdict in this case on the punishment phase, since the defendant was earlier found guilty of this second-degree felony of indecency with a child. Let me see the lawyers up here for just 1 minute, please. Thank you. We're going to review some legal matters from the Code of Criminal Procedure, and we are now ready to proceed. I'm going to ask the bailiff to please bring out the jury, and the alternate jurors will be brought back in. We will receive the verdict in this punishment phase of the jury trial. I see you. What do you think? Oh, yeah, we're gonna give you some documents for work or school or other purposes that show that you were here. Yes, sir. Oh. And the record shall show that the jury is seated in the courtroom, Ms. Ramos. As the foreperson of the jury, we have received a message on behalf of the jury from you that the jury has reached a verdict in this punishment phase of this trial for the second-degree felony of indecency with a child. Is that true, ma'am?
Yes, Your Honor.
Is this verdict a unanimous one? That is, one that is agreed upon by all members of the jury?
Yes, Your Honor.
Or any of the jurors disagreeing with your foreperson's representations? No disagreement is indicated. It does indeed appear to be a unanimous decision in this punishment phase. Please pass the documents as before to the bench. You may be seated. Thank you, ma'am. The court will review for proper forms and publish the verdict. Whatever this verdict is, please, no outbursts. That would be a contempt matter. And no, I do not want to punish anybody for interrupting the proper decorum of this courtroom. In cause number 23-41503, in the case of the state of Texas versus Horatio Trevino, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 10 years. That is the verdict of this jury. It is signed by the jury foreperson. It is received, and it is made a part of the record for all purposes. You may be seated. Ladies and gentlemen, at this time, your duty as jurors is complete. At the beginning of this trial, I placed each of you under a number of instructions. At this time, I am releasing you from these instructions which have previously been given to you. However, one final additional instruction. Once you are discharged, you are released from your oaths of secrecy. You will be free to discuss this case and your deliberations with anyone. And alternatively, you are also free to refuse to discuss this case, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a little bit of time, the attorneys will be released, and they always like to get any input and feedback from jurors if you're willing to stand by outside and wait for them. That's always helpful to lawyers. But you don't have to wait. You can move on with your life. And I want to again express our profound thanks for your time and your energy. It's important that people come forward for jury service. The Constitution, what this flag stands for, we the people of the United States, is what this Constitution begins with. We the people, all of us. At times, we are part of the process. We make decisions, important decisions, whether it's being a juror or voting for your public officials. It's vital because this is self-governance. There is a good reason why we lead all the other nations on this planet as the example of freedom and fairness. So I want to thank you for honoring your duty. I hope to have the honor to work with you in the future Until then, may God continue to bless Jefferson County and her citizens, and you are free to go. Thank you very much. And again, alternates, thank you for your vigil. We didn't get to use you in there, but thank you. Just as soon as we would not have someone available as an alternate, we would need an alternate. And unless there's 12, then it becomes a mistrial and we'd have to start all over again.
By herself.
Lacey is going to be out there with written documents for work or school or other purposes that shows that you were here. Thank you very much. You're going to have, if I hear you, like unable to focus on this, ladies and gentlemen, if you need to leave, please do so, but you can't interrupt the proceedings. Thank you for, I know this is difficult. Do your best, please. Compose yourself. Thank you. Is there any legal reason why formal judgment should not be assessed at this time?
No, Judge.
Horatio Trevino, you came before this court in a jury, entered a plea of not guilty to the offense of indecency with a child, a second-degree felony. The evidence was submitted and the jury was charged by the court. And after deliberating, the jury returned a verdict finding you guilty of the offense of indecency with a child as alleged in the indictment. Evidence was thereafter presented on the punishment phase of this trial, and after deliberating, the jury assessed your punishment at 10 years confinement in prison. Any formal objection before the final rendering of judgment and sentence here?
No, Judge.
The jury did not recommend that you be placed on community supervision in its decision. Therefore, it is the judgment of this case that you are indeed guilty of this second-degree felony of indecency with a child, and that you shall be punished in accordance with the jury's verdict. Therefore, it is the order of this court that you, Horatio Trevino, having been adjudged guilty of this second-degree felony of indecency with a child, and who's punished 10 years imprisonment in the Texas Department of Criminal Justice's Institutional Division, or prison, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 10 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the Sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence shall commence this day. You will receive credit for all time periods of detention that you have earned as provided by law up to this time. Anything to add by the state of Texas?
Nothing from the state judge.
The defense.
No, Your Honor.
These proceedings are concluded. This court is in recess and the defendant shall be taken into custody immediately.
The courtroom fell silent as the jury delivered its final decision in the case of State of Texas versus Horatio Trevino. After careful deliberation, the jury found the defendant guilty of indecency with a child, a second-degree felony, and moved into the punishment phase of the trial. In a unanimous verdict, the jury assessed the sentence at 10 years in the Texas Department of Criminal Justice prison system. With no recommendation for probation or community supervision, the court formally accepted the decision and entered judgment accordingly. The judge emphasized that all legal procedures had been followed, confirming the conviction and ordering the defendant into custody. Horatio Trevino was remanded to the Jefferson County Sheriff and will begin serving his sentence immediately, with credit given for time already served. As the jury was released from duty, the judge thanked them for their service, reminding them of the importance of civic responsibility and the role of citizens in the justice system. With that, the proceedings concluded and the courtroom was officially recessed. A case that began with serious allegations ended with a firm prison sentence, marking the final chapter in this courtroom decision.